Greetings to the gods. Welcome back to my channel. Today we are continuing Encyclopedia Britannica, 11th edition, 1910. We're reading Trust and Trustees. Rights and duties of the trustee. The principal general properties of the office of trustee are these. 1. A trustee having once accepted the trust cannot afterwards renounce. 2. He cannot delegate it, but an inconvenience which formerly attached to dealings with trustees and trust property, in consequence partly of this rule, and partly of the liability of persons dealing with trustees to see that money paid to them was properly applied, was largely obviated by Section 17 of the Trustee Act 1893, replacing Section 2 of the Trustee Act 1888. Which in effect provides that a trustee may appoint a solicitor to be his agent to receive and give a discharge for any money or valuable consideration or property receivable by the trustee under the trust, by permitting the solicitor to have the custody of and to produce a deed having in the body thereof or endorsed thereon a receipt for the consideration money or other consideration, the deed being executed or the endorsed receipt being signed by the trustee. And a trustee is not chargeable with breach of trust by reason only of his having made or concurred in making any such appointment. And the producing of any such deed by the solicitor is a sufficient authority to the person liable to pay for his paying to the solicitor without the solicitor producing any separate or other direction or authority in that behalf from the trustee. 3. In the case of co-trustees, the office must be exercised by all the trustees jointly. 4. On the death of one trustee, there is survivorship. That is, the trust will pass to the survivors or survivor. 5. One trustee shall not be liable for the acts of his co-trustee. 6. A trustee shall derive no personal benefit from the trusteeship. The office cannot be renounced or delegated because it is one of personal confidence. It can, however, could be resigned, and legislation has given a retiring trustee large powers of appointing a successor. The liability of one trustee for the acts or defaults of another often raises very difficult questions. A difference is made between trustees and executors. An executor is liable for joining in a receipt pro forma, as it is not necessary for him to do so, one executor having authority to act without his co-executor. A trustee can show that he only joined for conformity and that another received the money. The rule of equity by which a beneficiary who consented to a breach of trust was liable to indemnify the trustees to the extent of his interests has taken definite statutory shape in Section 45 of the Trustee Act 1893, replacing Section 6 of the Trustee Act 1888, which enacts that when a trustee commits a breach of trust at the instigation or request or with the consent in writing of a beneficiary, the High Court may, if it thinks fit, and notwithstanding that the beneficiary is a married woman entitled for her separate use and retained from anticipation, make such order as the court seems just for impounding all or any part of the interest of the beneficiary in the trust estate by way of indemnity of to the trustee. The rule that a trustee is not to benefit by his office is subject to some exceptions. He may do so if the instrument creating him trustee specially allows him remuneration, as is usually the case where a solicitor is appointed. The main duties of trustees are to place the trust property in a proper state of security to keep it, if personality, in safe custody, and to properly invest and distribute it. A trustee must be careful not to place himself in a position where his interest might clash with his duty. As a rule, he cannot safely purchase from his Setiki trust while the fiduciary relation exists between them. Investments by trustees demand special notice. The Trustee Act of 1893 has consolidated the law on this point and provides, as it were, a code or charter of investment authorizing trustees unless expressly forbidden by the instrument, if any, creating the trust, to invest trust funds in various modes, of which the more important are as follows. In any of the parliamentary stocks or public funds or government securities of the United Kingdom, on real or heritable securities in Great Britain or Ireland, in stock of the Bank of England or the Bank of Ireland, in India 3.5% stock and India 3% stock, in any securities, the interest of which is for the time being guaranteed by Parliament, in consolidated stock created by the London County Council, in the debenture or rent charge or guaranteed or preference stock of any railway company in Great Britain or Ireland incorporated by special act of Parliament and having during each of the 10 years last passed before the date of investment paid a dividend at the rate of not less than 3% on its ordinary stock. In the debenture stock of any railway company in India, the interest on which is paid or guaranteed by the Secretary of State in Council of India. In the B annuities of the Eastern Bengal, the Eastern Indian, and the Sindh, Punjab, and Delhi railways, and also in deferred annuities comprised in the register of holders of annuity class D and annuities comprised in the register of annuitants class C of the East Indian Railway Company, in the stock of any railway company in India upon which a fixed or minimum dividend is in sterling is paid or guaranteed by the Secretary of State in Council of India, or upon the capital of which the interest is so guaranteed, in the debenture or guaranteed or preference stock of any company in Great Britain or Ireland established for the supply of water for profit, and incorporated by special act of Parliament or by royal charter, and having during each of the 10 years last passed before the date of investment paid a dividend of not less than 5% per annum on its ordinary stock, in nominal or inscribed stock issued or to be issued by the corporation of any municipal borough having, according to the returns of the last census prior to the date of investment, a population exceeding 50,000, or by any county council under the authority of any act of Parliament or provisional order, in any of the stocks, funds, or securities for the time being authorized for the investment of cash under the control or subject to the order of the High Court. Trustees may from time to time vary any such investments for others of an authorized nature. The statutory power to invest on real securities does not, of course, authorize the purchase of realty, but by Section 5 of the Trustee Act 1893, a power to invest in real securities, in the absence of express provision to the contrary, authorizes investment on mortgage of leasehold property held for an unexpired term of not less than 200 years and not subject to a greater rent than 1 shilling a year, or to any right of redemption or condition of re-entry except for non-payment of rent. The position of trustees in respect of what was frequently an undue personal responsibility for the administration of their trust has been much improved by Section 8 of the Trustee Act of 1888, not repealed by the Trustee Act of 1893, and Section 3 of the Judicial Trustees Act 1896, subsection 1896. Subsection 1 of the former enactment with some omissions runs as follows. In any action or other proceeding against a trustee or any person claiming through him, except where the claim is founded upon any fraud or fraudulent breach of trust to which the trustee was party or privy, or is to recover trust property, or the proceeds thereof still retained by the trustee or previously received by the trustee and converted to his use, the following provision shall apply. A. All rights and privileges conferred by any statute of limitation shall be enjoyed in the like manner and to the like extent as if the trustee or person claiming through him had not been a trustee or person claiming through him. B. If the action or other proceeding is brought to recover money or other property and is one to which no existing statute of limitation applies, the trustee or person claiming through him shall be entitled to the benefit of and be at liberty to plead the lapse of time as a bar to such action or other proceeding in the like manner and to the like extent as if the claim had been against him in an action of debt for money had and received. The statutory period of limitation which trustees are thus permitted to plead is the 6-year fixed as the period of limitation for actions of debt by the Limitation Act 1623. It has been decided on the above section that in the case of a breach of trust consisting of an improper investment of the trust funds, time begins to run in favor of the trustee from the date of the investment. Subsection 3 of the Judicial Trustee Act 1896 provides that if it appears to the court that a trustee, whether appointed under that act or not, is or may be personally liable for any breach of trust, whether the transaction alleged to be a breach of trust occurred before or after the passing of that act, but has acted honestly and reasonably and ought fairly to be excused for the breach of trust and for omitting to obtain the directions of the court in the matter in which he committed such breach, then the court may relieve the trustee either wholly or partly from personal liability for the same. Owing to the generally reduced rate of interest obtained for money invested on trust securities, the court has in several instances, and even as against defaulting trustees, charged them with interest at 3% per annum instead of 4%, which was formerly the recognized rate, upon sums found due from them to the trust estate. Under the old law, trustees could not safely advance on mortgage more than 2/3 of the actual value of agricultural land or 1/2 of the value of houses. This 2/3 rule is now made statutory by Section 8 of the Trustee Act 1893, which enacts that a trustee lending money on the security of any property on which he can lawfully lend shall not be chargeable with breach of trust by reason only of the proportion borne by the amount of the loan to the value of the property at the time when the loan was made, provided that it appears to the court that in making the loan, the trustee was acting upon a report as to the value of the property made by a person whom he reasonably believed to be an able practical surveyor or valuer instructed and employed independently of any owner of the property, whether such surveyor or valuer carried on business in the locality where the property is situated or elsewhere, and that the amount of the loan does not exceed 2 equal third parts of the value of the property as stated in the report, and that the loan was made under the advice of the surveyor or valuer expressed in the report. The same section protects trustees for not investigating the lessor's title when lending on the leasehold security and for taking a shorter title than they might be otherwise entitled to on the purchase or mortgage of any property, if they act with prudence and caution. By Section 9, replacing Section 5 of the Trustee Act of 1888, trustees who commit a breach of trust by lending more than the proper amount on any property are excused from making good any more than the excess of the actual loan over the sum which they might have properly lent in the first instance. Right? So that was the duties, the rights and duties of the trustees. And it shows here clearly the power and control that the trustee has over the trust property, because remember, the trustee is the apparent owner. So when we talk about owning nothing and controlling everything, we this is what we're speaking about. We want to be the trustees over the property. The trustees is the one that has the power and control over the property. And a trustee is seen is holding a very high position of prudence and respect. They are looked upon as being very honorable people and honorable men. All right. So this part here that we just read, the rights and duties of the trustees, clearly shows how the act, they created all these acts and they made all these amendments to these acts that they brought forward and amended, and they brought forward certain parts and they didn't repeal certain parts to protect trustees and give the trustees the ability to perform their duties with little concern as to liability for personal responsibility. All right. So this is just a simple example here of the rights and duties of the trustees. All right. So in your state or wherever you live, you can look for the Trustee Act and you can read it and get familiar with it. Because in going forward and dealing with trusts and estates, the position of trustee will be a position that we will be uh, holding to administer the trust. So we must know the powers of the trustee by recognized by statutes, also what powers we can give to the trustee via the instrument when setting up and establishing our private trusts. All right. So we continue. Rights and duties of the Seteki Trust. These may be a great extent deduced from what has been already said as to the correlative duties and rights of the trustees. The Seteki Trust has a general right to the due management of the trust property, the proper accounts, and to enjoyment of the profits. He can, as a rule, only act with the concurrence of the trustee unless he seeks a remedy against the trustee himself. Right? So the trustee has a right to enjoy property. They have a right to the due management of the property. They have a right to the enjoyment of the profits. So the beneficiary has all those rights to the due management, proper accounts, and the enjoyment of profits. And the trustee, the one who has control of the trust property, they have a duty to due management, proper accounting, and to bring profits to the trust. All right. Judicial trustees. Judicial trustees. The Judicial Trustees Act of 1896 inaugurated a semi-official system of trusteeship which was new in England but had been known in Scotland for upwards of 150 years. The general scope of the Act is indicated by Section 1 and the 1, which runs as follows. Where application is made to the court by or on behalf of the person creating or intending to create a trust, or by or on behalf of a trustee or beneficiary, the court may, in its discretion, appoint a person in this act called a judicial trustee to be a trustee of that trust, either jointly with any other person or as sole trustee, and if sufficient cause is shown, in place of all or any existing trustees. The Act and the rules made under it, the Judicial Trustees Rules of 1897, provide that judicial trustees shall be under the control and supervision of the court as officers thereof, and may be paid for their services out of the trust property. So this may be a very good act for us to get to read, the Judicial Trustees Act of 1897, if we can find it, because what we have today we have today are representatives who are trustees or public servants who are trustees. And if we have this information, if we get this information, it may give some clarity as to the functions and duties given by the court to a judicial trustee. And we may be able to superimpose it on the duties that we see being performed today by our trustees, and how else we can hold them accountable before the courts. All right, so this may be a nice document to get if we can get it. The Judicial Trustees Rules of 1897. You know, we have rules of court, we have equity rules, we have the common law rules or the at law rules, which has been merged into one venue, right, by the Judicature Act, right, of 1873. Now we see here we have Judicial Trustees Rules. If we can get this, it may be very informative. All right, we continue. The trust accounts are to be audited annually and a report thereon made to the court, which has power to order inquiries into transactions connected with the administration of the trust. A judicial trustee may be required to give a security and in any case has to keep the trust account with a bank approved by the court and deposit title deeds and other documents of title in such custody as the court directs. And if you have to give security, in modern times, we know the holders of office have to give an oath, and an oath is what your word, and an oath is what your word is what a bond. All right. So if they have to give security, they have to give a bond. All right. Communication between judicial trustees and the court with reference to their duties are permitted to be made with little or no formality, and strict proof of facts may be waived in proper cases. The act may, in short, be described as an attempt to provide for an official check upon the administration of trust while avoiding the formality and expense indent to the procedure in an administration action. So that's a judicial trustee. All right. So a judicial trustee, court appointed. Now we're going to see what a public trustee is. So a step further was taken by the Public Trustee Act 1906, which established the office of public trustee. By the act, he is a corporation sole with perpetual succession and an official seal, and may sue and be sued under his official title. He may, if he thinks fit, act in the administration of estates of small value as custodian trustee or as an ordinary trustee. He may be appointed a judicial trustee or administrator of a convict's property. The law of trust generally is applicable to him, and he can act either alone or jointly with other persons. He has an absolute discretion as to whether he will accept or not any trust, but cannot decline acceptance on the ground only of the small value of the trust property. He cannot accept any trust which involves the management or carrying on of a business except in certain cases authorized under rules appended to the Act. He cannot accept a trust under a deed of arrangement for the benefit of creditors, nor of an insolvent estate, nor one exclusively for religious or charitable purposes. His powers and duties are dealt with by the Act under three headings: in the administration of small estates, on the application of any person entitled to apply to the court, that is, the High Court, and as respects trusts within its jurisdiction, the County Court, for an order for administration of any estate, the gross value of which is proved to the satisfaction of the public trustee to be less than £1,000, he may administer the estate, and must do so if the persons beneficially entitled are persons of small means, unless he sees good reason for refusing. By declaration in writing, signed and sealed by him, the trust property other than stock vests in him, and the right to transfer or call for the transfer of any stock forming part of the estate, provided that he does not exercise the right of himself transferring stock without the leave of the court. This general provision also does not apply to copyhold, in respect of which he has the same powers to convey them as if he had been appointed under Section 33 of the Trustee Act of 1893. Power is given to the court to order, for reasons of economy, that an estate being administered by the court be administered by the public trustee. And the power lies in the court. Right? So you see, we need to not be afraid of going into those venues. We need to learn trust, study estates, study trust law, learn how to administer our trust, learn how to enforce our trust. And that is where we will get our remedy. That is where we will get us our enforcement. We'll get those remedies and those relief in the court, in the high court. All right? We continue. 2. As custodian trustee. The public trustee, if he consents to act, takes an oath of office. If he consents to act, may be appointed custodian trustee on an application to the court or by the testator, settlor, or other creator of any trust, or by a person having power to appoint new trustees. When he is so appointed, the trust property is transferred to him, and if he were the sole trustee, but the management of the trust property and any discretionary power remain vested in the other trustees. His relations with the managing trustees are further defined by the Act. So that is a custodian trustee. So those who hold our securities, are they custodian trustees who have given oath to act as such? 3. As an ordinary trustee. The public trustee may be appointed trustee, executor, etc. of any will or settlement or instrument of any date, either under his official title or other sufficient designation. In a will, a sentence to the following effect would be sufficient. Quote, I appoint the public trustee, executor, and trustee of this my will. Where the public trustee has been appointed a trustee of any trust, a co-trustee may retire from the trust under Section 2 of the Public Trustees Act of 1893, notwithstanding that there are not more than 2 trustees, and without such consents as are required by that section. The Consolidated Fund of the United Kingdom is liable to make good all sums required to discharge any liability which the public trustee, if he were a private trustee, would be personally liable to discharge, except where neither the public trustee nor his officers has contributed to it, and which neither he nor any of his officers could by reasonable diligence have averted. A person aggrieved by any act or omission or decision of the public trustee in relation to any trust may apply to the court, and the court may make such order in the matter as it sees fit. The Act contains provisions for the investigation and audit of trust accounts, which may take place on the application of any trustee or beneficiary. If the parties do not agree upon a solicitor and public accountant for the purpose, they are appointed by the public trustee, who has entire discretion over the source from which the expenses are to be defrayed. The fees payable under the Act are fixed by the public trustee fees order. They are of 2 kinds, fees on capital and fees on income. The object of the department is not to make a profit, but merely to pay expenses.